It is indeed a privilege that you have protected, provided, and you have done everything to us from we are awoke from morning and right through the day, even until now. We're thankful, oh God, for another opportunity to praise your name, to bring glory and honor according to your will. Tonight, we want to specially pray for everyone who is on the platform and those who are listening from near and far, those who are members and those of our friends that we have invited to listen to this wonderful presentation that most time as a church is kept on the back burner. And it's only when incidents happen, then hands are thrown in the air. Tonight, the women's ministry, we pray a special prayer as they continue to lead the women of the Halse district of churches and by extension others. That as this presentation is done on wills, an estate, we ask for a divine touch for the presenters. We ask that they will speak with clarity, that the platform, the instruments that are being used will stay up. The internet will not fail us tonight because everyone wants to hear the information and wants to order our lives as it relates to. So thank you, Lord, for the presenters. Thank you for the women of the district. May we continue to live godly lives. And as we learn, may we not be selfish, but we will tell others about what we have learned so they too can make informed decision. Thank you for our pastor and his wife and his family, and for all boys and girls, and for the opportunity to serve you in this part of the vineyard. May we be faithful to the end. May we be blessed at the end of the presentation, and may it set the pace for the rest of the week. And may we continue to connect with you. This is the prayer with thanksgiving in Jesus' name. Amen.
Good night, everyone. It is really a blessing to be here on this platform tonight. And so the Women's Ministries Department of all four churches welcome you to this very special presentation tonight. It is not one of our usual Sunday night evangelistic meetings, but I can guarantee you that what we're going to be hearing tonight, it will help us to be better Christians, make conscious decisions, and is knowledgeable so we can help to share the information to somebody who needs information, especially this information at this time. And so we welcome everyone, welcome our pastors, our elders, and all those who are joining us on YouTube, we welcome you also. And I trust and hope that as we sit and listen tonight, that we will have our questions ready, because at the end of the presentation, we will have a question and answer section for you to ask the questions as much as possible. And so we welcome you, but we especially welcome Sister Claudine Linton. Sister Linton is the wife of Elder Linton, who was one of the speakers at the Fires of Hope online evangelistic series. And we're happy that she has accepted the invitation to be with us tonight. She is an attorney at law, and we're happy for her and happy for her ministry. She is a member, an active member of the Mile Valley Seventh-day Adventist Church. And even though she resides out of parish, out of Manchester, but she's still active at her church. And we want to say, Claudine, we're happy for you, and we're happy to have you with us tonight. We're also going to be having one Sister Palmer. Sister Rowe should have been here, but then Sister Rowe will not be here, but we have Sister Palmer. Sister Palmer is from Manchester, from the Maranatha Church. And so she will be assisting Sister Linton tonight in her presentation. Brothers and sisters, I pray that as we listen tonight, that our hearts will be blessed and we will learn enough so that we can be better citizens, better Christians, make conscious decisions, And so we will be able to assist someone else in our society. So with all that said, we welcome you. Have a good night. And as before Sister Linton comes, we will be blessed with a special message from Sister in song from Sister Donna. Sister Donna will sing for us at this time.
There are things that I love and hold dear to my heart. They're just borrowed. They're not mine at all. Jesus only lets me use them just to brighten my life. So remind me, dear Lord, roll back the curtains of memories now and then. Oh, show me where you brought me from and where I could have been. Oh, remember, I'm human and humans forget. So remind me, dear Lord, nothing good, yes, have I done, oh, to deserve God's own son. I'm not worthy of the nails prints in his hand. Yet he chose the road to Calvary just to die in my stead. Oh, why he loves me, I don't understand. Roll back the curtains of memories now and then. Lord, show me where you brought me from and where I could have been. Oh, remember, I'm human and humans forget. Oh, so remind me, dear Lord. Oh, roll back the curtain of memories now and then. Lord, show me where you brought me from and where I could have been. Oh, remember, I'm human and humans forget. Oh, so remind me, dear Lord. Oh, remind me, dear Lord.
Amen. Amen.
Good night, everyone. Good night, Halse District. Those here on the Zoom platform and those on YouTube, it is such a privilege and an honor to be here tonight, joining with you, the Women's Ministries Department, and sharing in this very special and interesting topic. Tonight, we are talking about the issue of estate planning and will preparation. And as Sister Barkley said, I have with me Sister Rashi Palmer, who has joined us, and she will also be assisting in the presentation tonight. Now, I know that some persons, when they hear the term estate or when they hear the term will, it goes hand in hand with the word death. right? Because these things take effect at death. And some persons may feel a bit down or fearful because it comes hand in hand with death. But brothers and sisters, at the end of this presentation, I want us to recognize that estate planning is very, very important, because even though it will come after your death, it will help your family members or those who are close to you to deal a bit better, I would say, with your death, knowing that there were proper plans in place to deal with what you would have acquired during your lifetime. So we're going to be looking at the whole topic of estate planning, but specifically we're going to be zeroing in on the preparation of wills. What are wills? How are they prepared? Who can prepare a will? What category do you fall in? So let's just get right into the presentation. Now, right. So the question is, do you think you can live forever? Every day we wake up and we are here, we thank the Lord for life. We thank the Lord for the blessing of, living to see another day. And we live year in, year out. But the answer, brothers and sisters, is no. A friend of mine once said that we all have an expiry date. And the Bible tells us to in Job chapter 14, verses 1 and 2. And I'll read it for you. It says that man is born of a woman. Man that is born of a woman is of a few days and full of trouble. He cometh like a flower and is cut down. He fleeth also as a shadow and continueth not. So the answer to this question, brethren, is that we will not live forever. At some point in time, we will close our eyes and we will go to sleep until Jesus calls us home. Now, we know that death is no respecter of persons. And as I said before, death is inevitable. And so while we're here on earth, we are admonished to occupy. And that means we're admonished to acquire assets. And I don't even want to go into the whole issue of, making those become our idols. We're not talking about that. We are talking about just acquiring assets so that we are comfortable here on earth while we are here. And so while we occupy, we must ensure that we make plans for these assets that we would have acquired during our lifetime after our death, right? I'm sure all of us have heard about deadlift. We know family members who have died, and when they have died, other persons move into their house to take up this, take up that. I just want to digress a bit to tell you that I heard recently of a gentleman who had died in the hospital, and in the same day, his own brothers went up to the house, and some people went into the closet, some people went into the kitchen, and they were just having a warm time, taking. And so it's very, very important that we understand, brethren, that we are to plan for these things so that we don't have a situation where, just a minute, brethren, we don't have a situation where we have left our family members in a confused state, and even in a state of disruption, because sometimes other people's assets can cause problems among our own family members. So this is what the estate planning helps us to do. I'm having a little challenge here changing my slides. Just a minute, brethren. Right, so we come now to the question, what is estate planning? And I first want us to look at the whole matter of what is your estate. And the dictionary just gives us a definition by saying that it is all the money and the property that is owned by a particular person, especially at death. And when we talk about property, we're talking about your assets, like your land, if you own a piece of land, if you own house, or if you have a car, if you have bank accounts, if you have livestock, even animals. Those are things that would be considered together as your estate. So the issue of estate planning is the process of acquiring and using and preserving your assets during your lifetime and arranging your affairs to transfer those assets effectively to your heirs and beneficiaries during your lifetime or after your death. Now, there are many approaches, or some persons may say tools, to this whole thing of estate planning. You can do it while you're alive. You can set up what are called trusts, or you can prepare a will. You can do something that is called an inter vivos transfer. Now, for example, you own a piece of property and you don't necessarily want to wait until after you have died to pass that property on. You can transfer the property during your lifetime to whomever you think best should receive that property. And so those two words, inter vivos, that is the English for that is in the person's lifetime. So you could also make preparations for your estate by transferring property even in your lifetime as well. There are powers of attorneys, joint ownership of property for those persons who are married. Sometimes when you purchase property, or more often than not, property is purchased jointly between the spouses. Now, of course, there are several benefits to estate planning, and I have just decided to look at these three. And the foremost thing is that you can choose how your assets will be distributed after your death. You can ensure, the second benefit is that you can ensure that your property will be distributed in an orderly and efficient way. And there's also a good benefit too, where you can minimize the payment of estate taxes, because best believe, brethren, even after you have gone, once you own property, the government still has a duty to obtain taxes from your property. It's called taxes on death, or death duties. So one of the benefits of proper planning for your estate is that you can minimize on the payment of estate taxes. Now, as I said earlier, we're going to be looking largely at the preparation of a will. But I wanted us to also recognize the opposite of not having made a plan for your estate and the effects, or what would transpire in that situation. Because I'm sure most, if not all of us, would have had a situation where we had a family member who passed and there was no will, but the family member would have owned property, whether it was a house, a car, bank accounts, and after his or her death, you would need to administer these assets. So let's look at this scenario. Now, this is something that I created, so it is not a real situation. It's something that I created. So this gentleman, his name is Mr. Mark Thomas. He's a businessman, and he operates a chicken farm, and they supply eggs to a hotel, and the business is registered in his name. He's married, he has 4 children, he has a parcel of land, and he lives in a house that is owned jointly with his wife. He has shares at VMBS, and he has 3 bank accounts. We see one at NCB, there's one at JMMB, and there's one at Scotiabank. Now, he went to work one day and he just collapsed after having lunch. By the time he was rushed to the hospital, he was diagnosed with a massive stroke and he died. At the time of his death, one of the children was an adult and the remaining 3 were minors. Now, Mr. Thomas he died without leaving a will. And the term in law is called intestacy, right? So the term that really describes how his estate will be administered is intestacy. Now, Sister Palmer is going to elaborate a little on this aspect. And as we've been talking, I want to just hammer home the point that making plans is headache, well, I should say headache less than not making plans. Okay, so Sister Palmer.
All right, good evening, everyone. So let's talk about what happens where somebody dies unexpectedly and there is no will in place. All right, so as was said earlier, an intestate is a person, an intestate person is someone who has died without leaving a will. And under the laws of Jamaica, there is an act called the Intestate Estate and Property Charges Act. Now, this act helps persons to know who should get what when there is no will. And so the lawmakers, I suppose, in their wisdom, decided that we need to determine who should get what. So it eliminates a lot of the rancor and a lot of the disagreements when persons die without leaving a will and everybody is fighting to get whatever is left. And so under the law, it says that where you die leaving a spouse and you also have children, then the spouse firstly gets all of what is called your realty, your real property. That refers to chattel, all movable items. So in this scenario, Mr. Thomas left bank accounts at NCB, JMMB, and Scotiabank, and he has shares with VMBS. His spouse, then Mrs. Thomas, would get all the money in his accounts and the shares at VMMBS, because these are considered to be real property. However, he also left a parcel of land and he left a house in which he owns jointly with his wife. So first, let's deal with the parcel of land. Now, who would get the parcel of land? The law says that the spouse should get 50% of real property, which is house and land. Now, I think I made an error earlier. I said real property refers to chattel. That is called personal property, pardon me. So personal property, anything that is a movable item, real property refers to house and land. So in respect of this parcel of land, 50% would go to Mrs. Thomas and 50% would be to her 4 children in equal shares. In respect of the house that they live in, it is a different situation that would now govern that, because it says that it was owned jointly with his wife. Now, in the usual case, let's say Mr. Thomas had owned this house alone, he was the only name on the title, so it's all his. Then the law of intestacy would kick in to say, all right, 50% of the house would go to him and 50% would go to the children in equal shares. However, because it was owned jointly with his wife, there's a whole nother aspect of the law that governs when land is owned jointly. When land is owned jointly, you're considered to be a joint tenant. And when there is a joint tenancy, there is what is called the right of survivorship. So what that means is whoever lives takes all. So because Mrs. Thomas survived her husband, when it comes onto this house that was owned with herself and her husband, then she would only need to note his death on the title and the house would go to her solely. So in this case, the house would not fall into intestacy, meaning she would not have to share it with anybody else. She would only need to note his death on his name on the title, note his death on the title rather, and then the whole of that property would then belong to her. The house goes to her. Now, we hear that there are minors in the estate. So there are 3 minor children and 1 adult child. Now, usually, when you are applying for when someone dies without leaving a will and now you're determined, you know who is supposed to get what, you still have to make an application to the court to have permission to distribute a deceased person's estate. So I know, and it happens a lot of time, clients come in and they think that once somebody dies, you can just go, even if you're supposed to be the wife and you're entitled to the house or you're entitled to 50% of whatever it is, you're not supposed to just go and take it. So yes, the chattel and everything belongs to you, but you must go through a process to the courts first. The court then gives you permission to distribute the estate according to law. And when there is no will, you have to make an application for what is called a grant of administration. And essentially, this is just permission from the court to distribute the deceased person's estate according to law, so that you can legally get the title in your name, you can legally get all the assets that belonged to the deceased person in the name of the persons to whom they're supposed to go. Now, because they're minors in the estate, the administrator general, however, has to step in. So usually you can make an application as the spouse. So Mrs. Thomas would usually make the application for a grant of administration, and then she can get 50% of what is to belong to her, and she can transfer the other 50% to her children. However, because they're minors in the estate, the administrator general is the one who is actually going to be the one to make the application. Why is this so? Because when it comes on to children, the administrator general wants to ensure that they're protected, because there are many times where children are entitled to house and land, and many times they don't get it. Persons sell it, they don't ever see a dime of the money, they don't see the house, they don't see the land. So in order to protect the affairs of children, the administrator general is the one who, under our law in Jamaica, is supposed to apply for a grant of administration. And now the administrator general would then become trustee on behalf of the minor children, and they will hold the estate or whatever they're entitled to on trust until those children attain the age of majority, or rather they get to age 18, they're adults. And then they are officially entitled to claim whatever is theirs. So in this case, the administrator general has to be the one to make a grant of application for administration in Mr. Thomas's estate. Have I dealt with all of the assets? No. So we also now have the business. I failed to tell you who would get the business. Now, again, that would be considered to be real property, and it would be distributed between the wife and the children if he was the sole proprietor and everything belonged to him. So the business may be on a piece of property, etc. It may own assets, and those would be shared between spouse and children. Mrs. Stewart Linton, I think you.
All right, thank you. Thank you, Sister Palmer. All right, so brethren, that was quite a mouthful, but I just want to summarize and to say to you, brethren, that this was a quite simple scenario, and this simple scenario can be quite a headache, and it can be a very long and drawn out process because of the fact that there were no plans in place to deal with the administration of Mr. Thomas's estate, right? Now we're going to move on now to look at the topic that we really want to be looking at tonight, and that is a will. Now, as I've been saying, I'm sure this is not a very unfamiliar topic, or this is not a very unfamiliar word to us. But just for a reminder, or just for the sake of those who may not know, let's just deal with the definition of a will. And so a will is generally a document in writing by which the person making it provides for the distribution or the administration of a property after his or her death. Now, document in writing means that it can be handwritten, it can be typewritten, or it can be generated by a computer, but it has to be in writing. So somebody cannot come to you and say, oh, John Brown did say, me did forget. John Brown did say the car must go to Mary Jane. That's not a will. A will is a document in writing, black and white on paper. And the will takes effect after the death of the person who has made it. And our very Bible tells us about this the effect of a will. And for those of you who didn't know, you can look at Hebrews chapter 9 verse 17, where it says, "For a testament is of force after men are dead, otherwise it is of no strength at the while the testator liveth. So while I am alive, my will is of no effect." My mother cannot come and take any property from me because she knows that I have written it in a will. No, it takes effect on my death or on your death. Now, there are words that you will hear being used that refer to the will. And so I want us to look at the word testator. So in the case of a male, this is the person who makes the will. But in the case of a female, the person who makes a will, the female who makes a will, is called the testatrix. All right, so these are just words that we use in law, but they are words for your learning as well. Who can make a will? Now, the law that governs preparation of wills and how wills are dealt with is called the Wills Act of Jamaica. And it requires that persons have not only the mental capacity, but the legal capacity to make a will. So the legal capacity, you must be over the age of 18 years. So if you're younger than 18, unfortunately, you can't make a will just yet. And the mental capacity means you must be of sound mind. So if you know that a person is mentally incapacitated, then if that person has made a will during the time when they were mentally incapacitated, then that will was not made of his that will was not made freely, and it can be a questionable will, and it can be one that is, it can raise questions of whether the will was made by fraud or by force or duress. So essentially, the person making the will must make the will freely. The person must want to make this will. All right. So the question is, who can make this will? Once you're married, you should make a will. Once you're a parent, and I'm sure quite a few parents are here this evening, you should make a will. Once you own assets, and assets, as we said, we look at a house, car, shares. Once you have any sort of investments, you should make a will. Once you're retired, you should make a will. If you have bad health, it's important for you to consider making a will. And if you're starting a new career, if you have a high-risk job, the list goes on. This is not an exhaustive list, but these are just some of the considerations or some of the categories of persons who can make a will. And I'm sure that many of us fit one or two of these categories. So let's look at the elements of a valid will. As I said, the Wills Act would have pointed out some the formalities that we must observe when making the will. And it's important to note, as Ms. Palmer mentioned, that on the death of a person, you can't just go and take and take and take. It is a court that gives the permission or gives the effect to the wishes of the testator or the testatrix. So when the court receives an application, whether for a grant of administration, as Sister Palmer mentioned, and in this case, for a grant of probate, where there's a will, the application that is made is called a grant of probate. So when the court gets that application, when all the documents are presented, if the necessary elements of the will are not there, then unfortunately, brothers and sisters, the grant of probate will not be given. Right? Sometimes that very will fall into intestacy, meaning that they will treat the will as if it was of no effect, and it would be as though the will never existed, and so the person would have died without leaving a will, if these elements are not contained in the will. So let's just look now at these elements to ensure that when we're preparing our wills, these things are in there so that we will not fall into the trap or the unfortunate situation of having a grant not given to us by virtue of an invalid will. So as I mentioned before, the mental capacity of the testator, right? So the testator needs to be over 18 years, sound mind. there must be a description of the testator. So I, Mary Jane, retired teacher of 7 Halse Hall Road, Halse Hall District in the parish of Clarendon. That's a description of the testator. The testator must also sign the will. If the will has not been signed by the testator or there's no signature at all, then that's not a valid will. Now, the will can be signed by someone else on behalf of the testator, right? But there must be a clause at the end to indicate what had happened. So the signature must be made in the testator's presence and based on the testator's instructions. Let's say, for example, as well, if the testator is illiterate, can't read, then the testator can put an X at the foot of the will, and then there needs to be a clause which says that the contents of the will were read to the testator and he understood and agreed to what was in it. Okay, so these are the considerations in terms of the signing clauses that we must bear in mind. So one, you can sign the will. That is the most ideal situation, signing at the foot of the will. If you are unable to do that, somebody else can sign on behalf of the testator, and that person must have done so in the testator's presence and with the testator's instructions. And the third one, if the testator is illiterate, then the testator can put an X at the bottom of the will, but there must be a clause which says that the contents of the will were read to the testator and he understood that that which was in the body of the will. Now, the testator must also have witnesses. So the person who is making the will must sign before his witnesses. And there are 2 witnesses that are required for the will to be valid. Now, the 2 witnesses must be present at the same time while the testator is signing. But when they are signing, they don't have to be in each other's presence, okay? So essentially, what that means is that there needs to be 3 persons present. The person who is signing the will or the persons whose will it is, and 2 persons who must watch the person signing. So if Mary Jane is creating her will, there must be 2 persons who can say, yes, I saw when Mary Jane signed at the bottom of this will on X date. Now, those 2 persons, they don't have to be in each other's presence when they are signing to the when they are witnessing their the signature of the testator. I hope you understand. All right, so all of these now would fall under the proper requirements of a valid will. And as I said earlier, if these are not met, then the grant of probate will certainly not be given, and it can make the will invalid. Now, a will needs an executor, okay? A person who will distribute or a person who will be responsible for administering your estate. So you need a head person who will distribute your assets in accordance to how you had wanted them to be distributed. So that person is called an executor. And anybody can be appointed as an executor. As a matter of fact, if even your own beneficiaries can be appointed as executors. So for example, if you have children and you want to give your children the property that you own or the car or the bank accounts or anything like that, you can also name them as the executor. What is important though is that usually it's recommended that you appoint more than 1 executors, because sometimes life happens, that same executor can die. And so you don't want a situation where your estate gets stalled because of the death of the executor that you had appointed. So it's important and it's recommended that you appoint at the very least 2 executors so that you can ensure that 1 is available to administer your estate. All right, you can I think you can go up to 4 executors, but at the very minimum, 2 executors are required, 2 executors. Now, this is very important. If you have gotten married, the law says that a will is revoked by the subsequent marriage of a testator. Excuse me. So if you have gotten married after writing your will, then it's crucial for you to prepare and execute a new will. And it brings me to the point that in general, you're free to change your will at any time. So let's just say that you have created a will 10 years ago and you know you have acquired new property and you probably have your nieces or any other persons who you want to give something to. You can change this will at any time, but you must ensure that the old will is destroyed so that there's no confusion at the time of your death as to which one of the will is to be probated. So just remember that one. Now there is a clause at the end of the will, which is called a residuary clause. And what this clause does is that it creates a catch-all phrase for everything that you would have acquired after you wrote the will. Now, the will operates from your death, right? But it also affects the property that you acquired after that will was signed. So it's very important that you put a residuary clause at the end of the will, which just says all the rest and residue of my estate I give and devise to XYZ. So in that way, anything that you had not mentioned in detail at the top of your will, those things would be covered in that catch-all phrase. And it's called the residuary clause. But just for simplicity, we call it a little catch-all clause to cover everything that wasn't mentioned. All right. So if you had bought a new car, or if you have some animals that you started to raise, if you have some goats that you started to raise in your retirement and you didn't put them in there, then this clause at the end of the will will take into consideration all of those new things. Now, I should mention also that when you create a will and you are giving your assets and what you own, your property, to different individuals, those persons who will receive the thing that you're giving, those persons are called the beneficiaries. And what you're giving is called a gift. So the person who you are giving your gift to is called the beneficiary. So your beneficiary can be your daughter, can be your husband, your son, your niece, can even be the church, right? Anybody who is receiving something based on your wish is called a beneficiary. And that which you are giving to the beneficiary is called a gift. So for example, if you're giving your clothes to the Women's Ministries Department, the Women's Ministries Department of Halse District would be the beneficiary, and the clothing would be the gift. All right. Now, let's just look at this scenario. What if the beneficiary dies before the testator? So if Mary Jane had gifted her parcel of land to Tom Stokes, and Tom Stokes has died before Mary Jane dies, right? What will happen is that the gift will lapse, or the gift fails, because Tom Stokes is no longer living. So Tom Stokes cannot benefit from this gift anymore. If it happens during the life of the testator, then the testator can also update the will and give that gift to someone else, right? If, however, there was no updating of the will, then that gift would fall to the residuary estate, and it would be dealt with according to how you had given your residuary clause at the bottom. The only exception, though, is that there's a provision in the Wills Act which says that if the deceased beneficiary is a child of the testator, then the Act provides for the gift to be transferred to the children of that child. So, for example, I saw Sister Wigan. So let's just say that Sister Wigan has gifted her property to her daughter. and for argument's sake, her daughter passes. The law says that that gift that she had gifted to her daughter can pass to the child of her daughter, which would be Sister Wigan's granddaughter, if you understand, right? So the law also provides for that. So in that case, that gift would not lapse, or it wouldn't fail. It would pass to the grandchild of the testatrix in this case. All right. So it's important for us, brethren. I know this can be quite a mouthful, but it's quite important for us to take this into consideration. And I have been saying quite a bit about land and house and bank accounts, but assets include the very things that you own in your house. So for example, young people, you may have a laptop, you may have your cell phone, you may have your iPad or your tablet. Those are gifts which you can pass as well. Some persons might have some nice chinaware in their homes. Some persons may have a nice mahogany bed. All of those things, anything that you own, that is of any monetary value, those things can be gifted in a will. There's one thing that I did not put in this slide, but it's very, very, very important. And it is the issue of the children. Once you have a child, it is very important. It's very important that you make proper plans for them. And it's even more important for those who are not married or for those who are single parents, because you want to ensure that your children are properly looked after. So in the will, you can also appoint a guardian who can take care of your children. And you can also determine how your funds or how your monies are to be dealt with in the care and even in the education of your children as well. So for example, if you had an account at Jamaica National, you can say that this account is to be used for my child's education until she finishes university. Or you can say this is to be used for the care and control of my child, and I want my sister Mary Jane to be the guardian of my child until she attains the age of majority. All right, so I didn't mention that in the slide here, but it's important that you mention the preparation for your children as well. A will also can deal with how you can take into consideration how your debts are to be dealt with. Many of us have debts, right? We are either paying for a house or a car, or paying for some furniture, or even our child's education, some tertiary education that we are still paying for. So a will can also tell how that is to be dealt with as well, and your funeral expenses, all of those things can be considered in a will. All right, what we will do now is a little activity. We're coming down to the end. We're going to be doing a little activity. So this is a scenario that we're going to consider, and we're going to create a will with the information that we have here. So what I want us to do is I want us to look at the scenario here. We're going to be looking at the scenario, and then I'm going to show you what a will looks like, and then we will try to put the information in. So the scenario that we have here is Sylvia Longmore is a teacher at a primary school. She was never married, but she has one daughter. Her mother lives with them. So her mother lives with both herself and her daughter, and she's her mother's primary caregiver. She has two bank accounts, one with her mother's name on the account and the other with her daughter's name. And so those two accounts are joint accounts. She owns a car, and she recently acquired a piece of land in Mineral Heights. That is probably a little far from Halse, right? I should have put Halse. But anyhow, what we're going to do now is that we're going to prepare a will for Miss Longmore, and we're going to appoint her sister to be her daughter's legal guardian, and her mother's caretaker. So let me show you how we can do that. All right, so brethren, I hope you would have taken some notes. Well, I should have mentioned that before. Sister Pam, I want you to help me with this one. Do you have the details of the scenario?
Yes, I can locate it.
All right. So let me just bring up the will. All right. Are we seeing this document here? It's called the last will and the testament of. All right. So I want your participation now, ladies. So one person, if you see where my cursor is, what will go here? You can open your microphones and you can tell me, one person, what should go here?
Sylvia Longmore.
Sylvia Longmore, all right. Now it's important. I should have given her a middle name because that is important as well. So let's just name her Grace. All right, so this is the last will and testament of Sylvia Longmore. We're gonna leave out the date, right? We're going to leave out the date. But again, Sylvia's name would go here. Right, and we said that she is a teacher. All right. And we're going to put that she lives in the Halse district. All right, in the parish of Clarendon. All right, so that's element number one. This is the description that we're giving of Miss Longmore. And clause number one says, I hereby revoke all former wills and testamentary dispositions by me made and declare this to be my last will and testament. Remember, we had said that if there are any previous wills, those ought to be destroyed so that we remove any doubt or confusion. All right, so I have here that in the second clause.
Yes, someone is saying that the form is not clear. I don't know if you can make it any bigger or something.
Okay, all right, let's try to zoom it a bit. Is that now clear?
Persons can always improve on
just
theirs.
like it needs to focus. So I can't make none of the words, like it's not focused. So I don't know if it's my phone or what.
Okay, well, I've tried to zoom it a bit. So I hope that will be a little bit better for you. All right. Let's hurry along to see now what we can put here for clause number 2. All right, Sister Wigan, give me a name of a cousin, please.
Joyce. Cousin Joyce Lane Reed.
Joyce Lane Reed, give me an address, please.
Right. 353 Silver Close.
And what is Joyce's occupation?
Farmer.
Okay, all right. Sister Thompson, are you there? Unmute your mic, Sister Thompson.
Yes, I'm here.
All right, may I have another cousin, please? We're appointing another executor, so I need another name.
Simone Valdine Edwards.
Simone Valdine.
Simone Valdine Edwards.
All right, give me an address for Simone, please.
550 Lead Close.
Say that again.
550 Lead Close.
Lead Close. Okay. I should say in the parish. Right. All right, so we've completed that, okay? So we see here, brethren, that we have appointed 2 executors, and incidentally, they are the cousins of Miss Sylvia Longmore. So she appointed Joyce Reed and Simone Edwards to be her executors. And you can see from the description that we have given their addresses and their occupation clearly in this will. Clause 3 says, I direct that as soon as possible after I am deceased, my executor shall pay all my just debts, funeral expenses, and testamentary expenses, and taxes and duties, if any. All right. So we had said, Sister Palmer, can you just help me know here? We had said that she recently acquired a house, I think.
Yes, so she has quite a piece of land in Mineral Heights.
Okay. So, all right. So we're going to say my land.
Right.
All right. So we need now to give the full description of this land. So we're going to say, for argument's sake, we're going to say 35 Lily Way, Mineral Heights, the parish of Clarendon, right? To my daughter, all right, so she has given the property to her daughter. All right, and here's her daughter's name for life. And we can put the address here. Let's just say she lives at 10 Gardenia Close, House Hall. All right. So let me just put here now the land. So you see here that her wish is for the land not to be sold, but should remain in the family. So she has given this parcel of land to her daughter, and it's for her daughter's life. You see that at clause number 4. And it says that the land is not to be sold, but should remain in the family. So at the death of her daughter, that property should remain in the family. All right. We said, I think that she had two bank accounts. So right. Let's say she has one at National Commercial Bank. So we're going to say my National Commercial Bank savings account at the Maypen branch. In the parish of Clarendon, account number 504-303 or 393-191. All right, so she's going to give this now to her sister. So she's giving this to her sister, Dawn Ann Mullings, for her to pay my funeral expenses, right? And then we can say the rest and residue of my accounts to be used by her for the care and upkeep of my mother, all right, Eunice Mary James, okay? So she has
Just a
wished,
quick,
go ahead.
would it be necessary to say who the relationship to United Mary, no, my mother, the sister Dawn Mullins? Would it be necessary to say account number that to my sister Dawn Ann Mullins? Would that be necessary?
Well, yes, yes, for clarity and for the avoidance of any doubt, yes. So we can put that there. Thank you, Sister Wigan. All right, and we had said that she had another bank account. So where are we going to put this one now? We can put this one at Jamaica National. And this one still at the Maypen branch in the parish of Clarendon. I'm going to just quickly borrow this account number. Right, and her daughter is Renee. All right, just for time, brethren, I'm not going to put in any more details here, but this clause could also read to, this also could read to say that to her daughter, Renee Gale, but is to be managed by the aunt who is Dawn Mullins, all right? Because, for example, if the child is a minor, then the child would not have access to the account right away until she has attained the age of majority. However, once she is once she's below the age of majority, then there needs to be a clause which says how the account is to be dealt with on her behalf until she attains the age of majority. All right, and then finally we can look at her car. We said she had a car, so it's not enough for you to just say my car, but you need to specifically state what model and make the car is and the registration number, so that this gift is clearly stated in the will. All right, so she's giving this to her daughter. And we're going to say that it is a 2012 Toyota Corolla, registration number 1055 GK. All right, and then she has her clothing here, and we can give that. All right, I'll just say to the women's Red Cross. All right, fine, Red Cross. And we can say the Maypen branch. And we can say here to be distributed to the less fortunate mothers or single mothers. All right. Now, we had spoken earlier about the residuary clause, which would take into account any property which was acquired or obtained after the will had been prepared. So here we see the residuary clause. This is what is called the residuary clause. This is what it looks like. All the rest, residue, and remainder of my estate of whatsoever kind and wheresoever situate, whether real or personal, previously acquired or to be acquired, I give, devise, and bequeath to my daughter. And we know the daughter's name, Renee, so we would take it down here. All right. And then on the very day that the testator prepares this will, this is a date that will go here. And then the testator will sign here. All right. And then again, we spoke about the witnesses. Here are the names of the witnesses and their addresses. All right. So these are the persons who will verify to say, yes, I saw when Miss Longmore signed this document. All right. It's always
Just for
advised.
emphasis,
Say that again.
sorry. Just for emphasis again, you said once the testator or the testatrix is going to sign, that the two witnesses should be there.
Yes.
Maybe not necessarily the both.
No, well, or let me say it again. The witnesses must be present at the same time to see the testator sign. But they don't have to be there at the same time for them to write their names at the bottom here. You follow?
I'm
So
trying to make sure it's, yeah. So
right.
if both are there when he's signing, why don't they sign the same time?
I was just about to say, ideally, what usually happens is that they do sign together. But things can happen. Let's just say, for argument's sake, you were called and you just say, oh, just look to see that she's signing or whatever. But it happens in rare cases. But more often than not, the two persons are there who just write to say that they were there.
Okay.
Right. Sure. All right, so that's basically what a will looks like.
That's another question.
Go ahead.
Is this an updated version? Because I'm trying to remember in my mind's eye if I did see the residual
residual clause.
What's the name again?
The residual clause. Yes.
Right.
Here it is.
Yes, but I'm asking because I'm looking at in my mind's eye at a form, but I don't remember that I've read that section of it, if I've seen that section. So I was wondering if the form is updated. Like you go to somewhere, you buy the form or they give out the forms and stuff. But I'm just saying that this aspect is kind of new to me. So I was wondering if it was an updated, a recent addition to the form, or it was always there.
Well, truthfully, it was always there, and I was going to touch on that point as well, because sometimes we tend to go and perhaps buy a will form and fill it out and so forth, but you can do it, but it is not ideal, because as you just mentioned a while ago, sometimes the will form doesn't have the residual clause at the bottom. So you want to ensure that you take care of everything possible. And so in doing that, it's best sometimes to maybe go to an attorney to have the will drafted in the best way possible. So
okay.
that
and there's a cost.
That would certainly be my answer to your question there. So that
and is there a cost?
Yes, sister. Yes,
be attached to. I was just asking if I go to an attorney, there's a cost that would be attached to it.
Certainly.
Okay. Just want to know.
Right. All right. So that is in effect what a very, very simple will looks like. This I didn't want to complicate it very much, but as I said, anything that has any monetary value can be placed in the will. So if you have other things, as I said, if you have a farm, if you have animals and livestock, if you have pots and bed and linen and everything can be named in this will. All right. And you want to make sure that you are very clear so that there's no confusion, and you spell out and describe what you are gifting to your beneficiary in very clear and concise terms. All right. So
is there a privacy in the will, like I must not make the other person know what I write in the will?
You mean when you say the other person, who are you?
Gifted, who are getting the gift?
Okay, well, you can write it in such a way that the executor gives that gift in confidence.
Because I've always like heard at funerals and so that persons are waiting just to hear what in the will to see if they whatever. That mean it was private. I didn't know anything about it.
Well, all right. So here's how it goes. Sister Palmer had mentioned earlier that a will or the contents of a will are not to be read out until you have obtained the grant of probate, because that the will does not take effect until the court grants the permission for the executor to distribute the contents of the will. So even if you're at a funeral and somebody maybe whispers, say, him get the house, you know, it may not necessarily be so, because when that thing goes to the court, you may hear that the will wasn't valid, and then it goes to intestacy, and then the other consideration is the Intestate Property Charges Act, which will tell you how the estate will be distributed. So that is why it's important when you are appointing your executor to consider the trustworthiness and the reliability of that person, because when you create that will, you pass it on to your executor, and that should remain with your executor. Is not something to be announced. So that is a consideration when you are appointing your executor. It must be somebody who can be true and confidential to your business.
Okay. It seems as if we're in the question and answer section. So, right. So,
Right.
I'm going to ask other persons if we have any questions. I know there are questions on YouTube also. So, we're going to try to read that. But anybody else online have any questions, Sister Thompson?
Yes, Sister Linton. Caveat. Could you just throw some light on that for us, please? And how do we apply one to a property?
Say that again. I didn't hear the question. Sister Palmer is also here to shed some light as well.
Okay, a caveat. Could you shed some light on that for me, please? And how do you apply that to a property?
Okay, I'll assist Mrs. Stuart Linton if you wish.
Sure.
Okay, so a caveat essentially is you alerting the registrar of titles that you don't wish for anything to happen to the property without your permission, or that you don't wish for any transactions at all to happen in respect of the property without you signing off on that transaction. So for example, let's just say a husband and wife, they have separated and they own property jointly. And the wife is concerned, perhaps she was the one who left the marital home, and she's concerned that the husband might want to sell the property and she might not get any of the proceeds of sale, or of course she has an interest in the property as husband and wife. If it is jointly shared, you have a 50% interest. If you are, say, hearing that your husband might sell it without your permission, you can go ahead and lodge with the registrar of titles that thing called a caveat, which says that this property should not be touched, transferred, sold without my permission or without me signing off on it. And how you can get to apply it is by way of an application and a declaration. So there is a form that you fill out, and then you have a declaration where you explain to the registrar why it is that you want this caveat to be lodged. What are your worries? If the registrar finds that it is a genuine concern and you indeed have an interest in the property, because it has to be somebody who owns it or has some sort of legal or equitable interest in the property, meaning you contributed to the building of it or your name is on the title. So once you prove that you have an interest in the property, then you do a declaration. Usually it is done with the assistance of an attorney at law who would know the requirements, and you send it into the registrar. And if it is approved, then nothing can happen to that property. It cannot be transferred, sold, nothing can happen to it unless and until you either give permission for it to be done or you are one of the persons who sign off on it to be done. So you're alerting the registrar that I have an interest in it and I want it to stay as is for now.
Thank you.
Okay, any other question?
Talk about,
Somebody,
Mr. Bartley, before you move on, we talk
Yes.
about joint tenancy, but there's also a thing that is called tenancy in common. So could we get some light on that also?
All right, so Sister Palmer had mentioned that in joint tenancy, there is what is called the right of survivorship. So if Sister Thompson and argument's sake, Brother Thompson own property as joint tenants, then if Brother Thompson dies, then all of that property now passes to Sister Thompson. On the contrary, or on the converse, if you own the property as tenants in common, it means that you own it in different shares. You can own it 50-50 or you can own it 30-40 or whatever. But in terms of the passing, there's no right of survivorship in that. So let's just say we use back sister and Brother Thompson. If Sister Thompson dies, then her percentage of the ownership will pass to her estate and not to the other owner. You follow what I'm saying, Sister
Okay.
Thompson?
Yes, ma'am. Yes, ma'am. Thank you very much. Yes.
Okay.
Okay, so another question in the chat. How long after the testator die, you can probate a will?
Sister Palmer, you can help me on this, but I think it's, I think,
I'm not seeing Sister Palmer. I don't know what happened. I'm not seeing Sister Palmer.
you know, funny enough, it's literally at the top of my head, but I think it's probably within a year. It's probably within a year.
Okay.
Because usually what happens is that if you wait until like after the year, then you have to apply, then you have to explain to the court why you waited so long to apply.
Okay. And,
Right.
and another question on YouTube said, can the names be written by someone else but must be present to sign? All right, let me ask the other question. If there is a beneficiary living in another country, is there a specific clause, phrase, or statement to not conflict with the laws, against the laws of Jamaica?
No, because the thing about it is that you would be making, well, what I should meant, the presentation was really on property that is owned in Jamaica, right? So therefore, if the gift is for somebody who lives outside of Jamaica, then there would not necessarily be any law that would govern that person outside of Jamaica because the gift is in Jamaica. So our laws would govern that, how the gift is distributed here. But if the gift was elsewhere, then there would be other laws which would be considered.
Okay. The other question, referring to witnesses, can the names be written by someone else but must be present to sign the documents?
No. Well, the role of the witnesses is to ensure that they saw when, we're gonna use Sylvia Longmore, when their role is to ensure that they can verify that Sylvia Longmore signed the document. So Sylvia cannot write Jennifer Bartley and Veronica Thompson at the bottom of her will if they're not there. They must be there to say, yes, she signed the will. I saw when she signed it. And it's important to note that the witness is also a person who will be needed when the application is being made before the court, because there's a document called the affidavit of the attesting witness, and that is where one of the witnesses will have to depone to say, I was there when the person signed. And this is a document that would be considered as evidence. So it is taken for the truth and honesty of the person.
Okay. And this is a very practical one that many of us have heard over the years. Persons are afraid of making wills because they think they're calling down death on themselves. And a lot of many of us as church persons we hear this every day and we see it happen. What can you say to us as members of the church as we relate to our members when it comes to this?
Well, I mean, if you want to give your relatives more headache when you die, don't make the plans, right? But if you want them to grieve, I mean, peacefully, and I'm putting it in the very most frank and simple way. If you want them to, I mean, think about it, brethren. Sometimes persons die suddenly, persons die tragically. It's unexpected. And my father always says, death is an enemy that we will never get accustomed to. So the death in and of itself is hard. But when you have to deal with the administration and the distribution of the property that was owned by that person, it complicates and it provides more burden for your living family members. So you're not calling down death on yourself. You're actually putting plans in place so that you, even in your death, you can say how I want my property to be distributed. So look at it this way. You are essentially just making plans for the effective and efficient distribution of your property, which will reduce any amount of headache, any amount of heartache and trouble between your family members. Nobody quarreling over dead left because everything has been accounted for and everybody knows what they're supposed to get.
Okay. And another point is that many of us believe that it's only persons who have plenty things, a whole lot of money and everything. Those are the only persons who make will. And you mentioned about even the little things that you have in your house, your cell phone and all of that. Many of us, we don't think about those things that we should write will for those things. And especially if we're young and we feel that we have a long time left.
Right. Everything that you own, as I said, can be written or can be noted in a will. And for those who are farmers, those animals are very, very important. Who is going to look after your animals? Do you want your animals to, you want them to be sold, you want them to be butchered, or is it that you want them to still remain in the field so that they can, eat a little more grass or anything like that? Those things you have to take into consideration as well. So it's not just about who have 3 acres of land, who have 3 vehicles, who have a business up in Maypen. No, everybody who owns something must make preparations or must make proper plans for how these things ought to be distributed.
Any other question, Mr. Wigan?
Could I get, for example, if I own a house, joint tenancy, and would both husband and wife make a will for the same thing?
Yes. Yes, you can. Yes, you can, because remember that you own the same house, but sometimes one would go before the other.
So I right to say that I'm leaving it for him, and him right to say he's leaving it for me.
Certainly.
So what when both die at the same time?
But the thing about it is that, remember, we had said that if you own it jointly, then naturally it follows that you're going to be the beneficiary.
What if both die together?
That's an interesting question. Do you mean at the same, for example, in some sort
In a
of
car
say,
crash.
vehicle accident or something.
Yes.
Well, it's interesting you raise that question because I do have a matter that was similar where a husband and wife they passed away in a motor vehicle accident, and so it comes. Remember that in joint tenancy you have the right of survivorship. So the question is who survived, who died first, and so it would come down to whomever was declared dead first. So, for example, if the wife was declared dead first, then the husband, he essentially, everything that would devolve to him under the laws of intestacy, then his family members would get the assets. If the if the wife passed away first, then the laws of intestacy operate to say, all right, her children and her, well, she has no spouse, so her children or her parents, they would be the persons to inherit.
But the two of them died together.
Right? They died together, but usually the time of death is different. So they might have died in the same motor vehicle accident, but you will always find that one person would have predeceased the other, even if it is by a minute. So sometimes it even comes down to when did the medical examiner declare one dead first. And also, interestingly too, there is this thought that males are a little more carefree. And so they usually consider that if a situation like that happens, the female is considered to the person who died last. But that is not necessarily something grounded in law. So it really does come down to when you look at the time of death declared, you'll have to work with that.
So you're saying in this case, only one side would have benefited.
Well, what I'm saying is if the wife passed away first, then whatever is the house, then is the husband's. And though he has died, then the laws of intestacy say, okay, if he has children, then everything goes to his children and then his parents, grandparents. So yes, because the right of survivorship means whomever survives gets all. It means whomever died last gets it.
Okay.
Wow, that's a new one. Learning
Yeah.
something. Read the form. Somebody on YouTube was asking, will this be a downloadable form with the capability to edit at the end of this session? I guess somebody would love to know. Because I guess this form, based on what Sister Wigan was saying, it's kind of different from the one that you buy.
Well,
But
truthfully
on
speaking,
YouTube,
this was not a form. It was not a form. It was actually a document that was prepared by an attorney. So we would encourage strongly that persons seek the aid of an attorney when you are preparing your will.
Okay.
So this was just a courtesy being extended to show how it is done.
Okay. Thank you. Anybody else with any question? I guess you made it all clear and easy, Claudine. So we have listened and we have learned quite a lot. It was eye-opening for many of us. A lot of the things I'm hearing for the first time, and I know that I'm sorry that more of the brethren were not here to hear the presentation, but we're happy that we had it. So without further ado, we're going to ask Sister Elson to do the vote of thanks, and then Sister Thompson will give us the closing prayer. Sister Elson. And Elder Mason is saying that we need a part 2. So we will work on that, Elder Mason. Yes, Sister Elson, go ahead.
Someone says that saying thank you is more than good manners. It is good spirituality. So Sisters Stuart Linton and Palmer, on behalf of the pastor and the entire Women's Ministry Department of the Halse District, we want to thank you for an enlightening and extremely useful presentation on estate planning, especially as it relates to wills. your advice to uncomplicate and to unburden our loved ones by not dying intestate, and to actually demonstrate and walk us through filling out a will is especially useful. So thanks again to you both for making this evening's program so rewarding. And we just pray God's blessing on your practice and all the best.
Thank you so much, Sister Elson.
Thank you very much.
Welcome.
Sister Thompson.
Let us bow our heads, Heavenly Father. We just thank you, we praise you, we lift you up, and we magnify you. Tonight, you have opened our eyes to a lot of things, and even when we don't want to plan, we need to plan in order to make things run smoothly. And so, Lord, we pray that as we leave this medium, you'll continue to minister to our hearts, that we will do what is right. And so in the end of it all, we will make things a little easier for our families. May you continue to bless Sister Linton and Sister Palmer, that as they continue to expound in their jobs, Lord, they will remember that you gave them wisdom, the knowledge, and the understanding. May you remember their families also. And as all of us continue to serve you, may we serve you with distinction. In Jesus' name, amen.
Amen.
Thank you all. Thank you, Sister Palmer. And I haven't seen Sister Palmer since she was a little one. I didn't even remember what her features looked like. Thank you very much for coming. Thank you, Claudine. And online also, we want to thank Chantel for coming, the president of the Adventist AY Federation of Manchester, which is sister of Sister Linton. She is on, and we thank you all for coming. And we will plan a part 2 to this, and we're going to plan it one afternoon, maybe during an AY program or something, so more persons can get the opportunity to share. Thank you very much, brothers and sisters, and have a good night.
Good night.
Night.